Welcome back to Radio Entrepreneurs. I'm Jonathan Freedman, and our next guest up, Mark Furman, our ACE reporter, speaking on entrepreneurship and the law. Welcome, Mark.
Jonathan, it's great to see you today.
Always great to see you. So I know you're always looking at timely and topical things that are going on in the law and how it may affect businesses and business owners and entrepreneurs. I guess we've got some new information out of California that you want to share with people.
Yes, Jonathan. It's really important that folks stay in touch with their lawyers and view them as advisors so they can keep up to date on the law. I'll just give you an example of recent law passed in California that went into effect January 1, 2024. In California, non-competes have been unenforceable for a considerable amount of time. They've been viewed as a restraint on trade. But there's a new law that went into effect, as I said, the first of the year, that makes such non-competes illegal and provides a cause of action, the right to sue by an employee if they're subject to a non-compete. So it actually
is that like having a sort of a clawback or like a historical, how should I call it? A change in ruling that puts more enforcement or more teeth because of that provision?
Yes, it's one thing to say that a non-compete is unenforceable. It's another thing to make it to make you liable for making having an employee sign a non-compete for the employee to be able to sue you for damages as a result of it. So this is very specific. What the law requires includes, first of all, it says they're void, but secondly, it requires that the employer notify the employee in writing in an individualized communication by mail or hand delivery and email that the non-compete is void. And that notice must be given by Valentine's Day 2024 to the employee. So
there's probably a lot of companies that are SOL since we've already passed that threshold, I guess, and opening themselves up to potential liability. I could see. So what that's saying to me, and without getting deep into the provisions of the law, it sounds like if you signed a non-compete 5 years ago with an employee that still is an employee, that you must go back and notify them that it's no longer valid. It opens you up to potential liability if you don't follow those provisions that you talked about.
Yes, and it doesn't matter where the contract was signed. So let's say somebody was working for Mage in Boston, and let's say the employee was subject to a non-compete, hypothetically, and the employee moves to California and is working for Mage in California. Well, this law applies to that employee because the law says it applies to anyone who's working in California. So this is a really it's always been extremely strict non-competes in California, but this makes it even stricter. And it's a trap for the unwary employer, frankly. But to me, so the takeaway is if somebody moves to California, it's not February 14, 2024 anymore, as we're speaking, Jonathan. You got to notify the employee like as quickly as possible. At least you got to mitigate the implications, and you've got to be mindful. And these developments in the change of the law is constant. The courts are making decisions every day. Legislatures are passing laws in 50 states every day. We have a fair amount of dysfunction in Washington, but when they can cobble together a coalition that has a majority. They even pass laws. And one thing all these laws have in common is they make the life of the business owner more complicated. They make it, they create more and more legal minds for entrepreneurs. So nobody can stay up on every legal development that will ensure that they're not violating some legal requirement. But what you can do to limit your risk is to, as I like to say, don't treat your advisors as an expense and solely look at them as an expense line item. Think of them as important advisors to protect you, whether those are your insurance advisors, your business consultants, your accounting force, your financial advisors, and your legal advisors. People need help in this incredibly complex regulatory environment in which we live and in which businesses are expected to conduct business and comply with all laws that may apply to them, whether they know about the laws or they don't. And
I think, as a wise man has said, that there's no such thing as ignorance in the face of the law, right? And I think you've used that term a lot. I guess it's the challenge for entrepreneurs in general, to your point, is how do you stay abreast of all these things, and how do you make sure that you're compliant? And the advice is have close contact with your advisors and your attorneys to see what has changed that may impact your situation. Because it's much less costly to be proactive and address it and send out a notification, perhaps, than it is to be hit with a lawsuit for not having notified an employee.
Correct. And let me just say, no lawyer is going to know the laws in detail in all 50 states and or worldwide, obviously. And so it's frequently necessary to consult with lawyers in other states. And that's how you provide efficient legal advice. And, I get consulted on Massachusetts law from folks that are out of state, and many lawyers do. And so I'm sorry, the business owners, that the regulatory world is so complex, but I'm not going to change it, and they're not going to change it. And I'd encourage them not to have the attitude that I'll worry about it if somebody sues me, and to try to prevent having legal problems. Because, as another thing I always talk about, is litigation is extraordinarily expensive, and we try to prevent it.
Wonderful advice, Mark, and always practical in terms of trying to be proactive to protect your clients. Mark Furman, Director and Shareholder, Tarlow, Breed, Hart Rodgers. If people want to reach out to you, talk more about this or other matters, what's the best way for them to reach you?
Email mfurman, Furman, at tbhr-law.com.
Excellent. Mark Furman, thank you so much for giving us some insight into timely and topical items that impact entrepreneurs, and your segment in Entrepreneurship and the Law. Mark Furman, Director and Shareholder, Tarlow, Breed, Hart Rodgers. Thanks for joining us today on Radio Entrepreneurs.